but my objection to that is that it contains items of hearsay. It infringes upon our ability to confront the witnesses who he says he's hearing that information from. It involves some speculation, and it also lacks foundation. What I mean by that is Mr. Copeland has been testifying on direct. But we've not yet gotten to the point where he's going into any detail about what he knows, what he purportedly knows about Donovan Thomas's murder. So he hasn't yet testified that this is what I know happened, or this is what I heard happen, or this is what I saw or think happened. This person was involved, this person was in a car, and that's my example, but we haven't gotten into those details as of yet. In the excerpts that I've indicated, he does go into that detail, and he is talking about hearing information from Demikian, from other individuals, and he gives great detail about this person was driving. So, for example, if you look at page 488, Your Honor, down towards the bottom, line 22, the detective asked him, for example, so it was Yak driving, Shannon with the AK, Nard with the pistol, and Duop with a pistol. And going over onto the next page, Mr. Copeland says, nah, I don't think Duop had no pistol. So he's going into, and I'm sorry, if you go down a little bit more to line 6, where he says, yeah, I just know Yak. They said Yak was the driver. So obviously when he says they said, right, he's referencing hearsay, but he's going into great detail. My problem is that they haven't asked him any of that yet. And if their reason for wanting this particular portion of the audio-visual interview played is that it is impeachment by contradiction, well, he hasn't said anything yet about these details that requires contradiction. They haven't laid the foundation. This is kind of something you addressed on yesterday, Your Honor. They haven't laid the foundation by asking him any questions so that they can now go into it and just carte blanche play what he says. Because what happens then, if you allow this, is they're playing the video, and essentially the testimony is coming out based on this audio-visual interview, as opposed to him testifying about it and either admitting or denying that this is what he knows. So my objection would be foundation, first and foremost, and then the other things that I've indicated, hearsay, inability to confront the witnesses that he says he gets this information from, who would be, I think they're going to say these are co-conspirator statements, right? Demikian Garlington, for example, he's a co-defendant. We can't call him and cross-examine. And then finally, that some of his testimony, some of his statements here is speculation. So that's my objection.
Okay. All right. Ms. Hilton?
Yes, Your Honor. So first, I'm going to start with the foundational argument that we have not asked Mr. Copeland about the night Donovan Thomas was killed. We did, in fact, ask Mr. Copeland about that. Your Honor, when I had
Ask him about the guns or who was in the car?
We did. So, Your Honor, on June 13th, we actually asked this series of questions. And this is all in relation to the night that Nutt was killed. My question to him was, after you left Mechanicsville, did you go anywhere after leaving Mechanicsville from what you remember? Yeah. Do you remember where you went? Pick little D up. Okay. And which little D are we talking about? The one that always be with me. Okay. Is that the little D you referenced as your son? Yeah. Do you remember where you picked little D up? Where did you pick him up at? McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to the McDonald's on Cleveland Avenue, was there anyone else with little D? Just him and Shannon. Anybody else? Just him and Shannon. When you picked up little D, what did Shannon do? What do you mean? You said you picked little D up. Did you also pick up Shannon? I said I picked them both up. When you picked up both of them, where did you all go? I blanked out after that. You blanked out after that. Okay, why did you blank out? Because they were saying that I got the phone call. Do you remember who called you? So I asked him what occurred in the car. What's happening? He says he blanked out. So at this point, if he blanked out, he does not remember anything that happened in the car, which would be the conversations that he had with little D. And well, what he's now saying Shannon, but previously he told the detectives that Nard was in the car with him. And I believe that I asked him further on, and we don't have this part of the transcript, did Nard ever get in the car with you? And he says, no. So, Your Honor, we have confronted him as it relates to what occurred. Let me go further. Excuse me. I'm going to go down to the transcript. Now, before Monton called you, did you, Shannon, Little D, have any conversation about Nut being killed? No, was his response. That's a complete contradiction to, that's impeachment by inconsistent statement that he said, no, they did not have any conversation about Nut being killed. So as far as foundation is concerned, we have met the burden of the fact that this statement now comes in, one, impeachment by contradiction, but two, as a prior inconsistent statement. As far as hearsay, Your Honor, you've already ruled that what Demekian told Copeland in the car comes in as co-conspirator hearsay. The court has already made a ruling on that. And when you look at page 488, excuse me, starting at line 1, Detective Thorpe's question is, okay, so let's go back to Nut. Make sure I got everything right. Demekian pretty much told you it was him, Shannon, Nard, Bentley. Copeland corrects him. Nah, it was Demekian and Thug, D and Thug and the girl. Supposed to went to Bentley's house. This is based upon what Demekian told him. He says, you feel me? And when they got finished doing that, they supposed to pull up on him at the house. But I think the girl Bushi, you know what I mean? That's the girl who's supposed to, she know what's going on. You know what I mean? This is the girl Shannon turned against me. You remember they came and shot at us while I was in the car? This is the girl who I thought told them that I was at the hotel with them. He's now referencing what he told the detectives about, I believe in the January 28th interview. He's now referencing what he told the detectives in January 28th about Bushi potentially setting up him getting shot at on the highway. And then detective says, right? Then Thorpe says, so it was Yak driving, Shannon with the AK, Nard with a pistol, and Doo-Wop with a pistol? He says, nah, I don't think Doo-Wop had no pistol. Okay, right. But you just know what seats, how everybody was sitting in the car. All you know is Yak was driving. Yeah, I just know Yak. They said Yak was the driver. Again, talking about with Demekian. Because he said, and that's based on what Demekian told you? Yeah. Little D? Okay. Did they say that anybody else or just in y'all circle? He says, nah. Like, I told people, you did? Because I just wanted somebody to believe that I ain't do it. Yeah, I told Big Boo who did it. Like, shit, boy, goddamn, they did. You know what I mean? I never know what was going to happen. I was just like, don't say nothing. Him telling what he told Big Boo. Then continue on. But I think if y'all, and it's indiscernible, but I think he's saying that Shannon told New Baby. I know Shannon too much. I think Shannon told New Baby himself. You feel me? And New Baby's his girl? Yeah, New Baby. So you know what I mean? Because the story came out, though. 2 people said it. What? That Shannon and them killed him. You feel me? Like Bentley's girlfriend is Nut's sister. Yes, his baby mom is Nut's sister. And you know what? You know what she told him? What? How could you be around him and he's supposed to kill my brother? And Bentley said, if you feel like he killed your brother, just let me know. One call and it's on. That's why me and Bentley fell out. You know what I mean? So again, he's offering that comment to say this is why him and Bentley fell out. Then he says, you know what I mean? Like, you don't let nobody tell you no shit like that. Nigga, you know I ain't had nothing to do with that nigga getting killed. Detective Thorpe says, I'm gonna make a phone call. Detective Thorpe actually leaves the room. And then Kenneth Copeland continues to say, you feel me? So when I tell Bentley that, bro, you sitting around here telling this girl, if she want me dead, just say it. And they going, you know what I mean? So I believe you when you're saying it. They would have killed me to get it off of him. And then he goes on and say, I told Thug that. And Thug was like, nah, he's just trying to throw her off. You know what I mean? Hell no, I ain't going for it. So, Your Honor, the hearsay portion that defense counsel is claiming is hearsay is not. It is the co-conspirator statement of Demekian Garlington when he told Mr. Copeland what happened the night of the murder. And we have laid the foundation to introduce that because we've asked Mr. Copeland here in court, what did you all talk about the murder when the three of you got in the car? And he says no. So this is a complete contradiction to that first assertion. So foundationally, it gets to come in as impeachment by a prior inconsistent statement. It is not hearsay because the court has already ruled that what Debekian told Mr. Copeland is a co-conspirator statement. And that really ends on page 489. Line 14, anything that Debekian told Copeland is from page 488, when Detective Thorpe is trying to clarify what Copeland said Debekian told him. And that goes all the way to page 489, line 12. And Thorpe confirms multiple times, this is based upon what Debekian told you. And he says, yeah. So again, this is the co-conspirator hearsay. After line 14, that's when he begins
What page now?
On page 489, that goes into who Copeland told about it. So Copeland is now saying, I told Big Boo about it. And he told Big Boo not to say anything.
Is that going from 480, line 14, page 489 to the end, 491 at line 10?
No, that's only from page 489, line 14 through page 489, line 24.
Okay.
Then when you flip onto page 490, this is Copeland telling the detectives that he thinks Shannon told New Baby. And he's saying that more people knew about the murder, so his thought is that maybe Shannon told New Baby. Now, that is speculation. The state has no objection to taking out that portion of it.
What part?
So that would be page 490, line 1 through 8.
All right.
And I would have to get the timestamps for
Mr.
that.
Short, you,
I mean, Mr. Adams is gonna argue irony of this, but.
it's your client, so that's what I wanted to ask you.
In
Okay.
addition to the overall statute,
We-
specifically, I'm also arguing that 491 through page
491 to what, sir?
490 lines 1 through 8, as Ms. Hill just said. That-
Okay, all right, yeah, well, I think that she's agreed to redact that as it pertains to your client,
Yes, sir.
among any other objections that are being lodged, to include the general objection about not playing the videos at all, so,
And I'll actually extend that to line 12, Your Honor.
so 1 to 12
Yes.
on page 490?
Yes.
All right, that can be omitted out. Anybody wish to have any discussion in regards to that particular omission of just 490 to lines 1 through 12? All right, hearing none, those will be edited out. Okay, what
And
else do you have?
Then he picks up explaining that
He being who?
Mr. Copeland picks up stating that at line 15,
Of what page?
490, that his baby mama is Nut's sister, referring to OG Bentley. And he goes in to say, you know what she told him? How could you be around him and he's supposed to kill my brother? And Bentley makes his comment, like, if you feel like he killed your brother, just let me know, one call and it's on. That's why.
Okay, let me just back up a second if I can interrupt you, sorry. When he being Mr. Copeland is talking about his baby's mama, who's that?
He's talking about
That the mother
Nuts.
of who's he referencing?
He's referencing Mr. Donovan Thompson's sister, who is also the mother of one of Calvin Treadwell's children.
We heard testimony about that.
Yes.
Okay, all right,
And
okay.
it's not hearsay
Hey
because
y'all,
he's given his reason why
welcome to another
him and Bentley
live
fell out.
testimony in the
So
YSL trial.
he's saying, he being
Also known as
Copeland
Total and Complete
is
Foolishness by
saying
Judge
that
Euro Glanville.
the sister
This
in a
was supposed to start about
conversation with
9:30. As
her
y'all can
child's
see, he ain't really been
father
on that
is
long,
saying,
so we already
how
still
could you be
in
around him? Meaning, how could you be
CP
around
time.
Copeland
But we're
if
gonna see
Copeland's
what's
supposed
going
to
on.
kill
We are
my
still
brother?
going through
And then Bentley's
the
response to that was,
transcript
if you feel like
and
he
what
killed
is
your
going to
brother,
be
just let me
redacted
know.
from
Won't call in
the
sworn.
jailhouse
Copeland is
interviews
saying
with
that conversation is the
Kenneth
reason
Copeland,
why
also known as Lil
he and
Woody.
Bentley
So
are no longer
let's see where this
friends.
goes for
And
today.
that furthermore,
Again, I appreciate all
he
of y'all
says to
hopping
Bentley,
through.
why would you let her say that to you? And you know that's not true. You know I have had nothing to do with him getting killed, him being Donovan getting killed.
Hey, Daphne.
And he also tells Bentley, bruh, you sitting around here telling this girl if she wants me dead, just say it. So, you know, I believe when y'all are saying they would have killed me to get it off of him. And then he being Copeland tells Thug about the conversation of Bentley with his girlfriend. And Thug's response to that was, he's just trying to throw her off. Like, don't worry about that statement. And so we believe that all of that comes in as relevant, that is non-hearsay in this case. So the entirety of the section, exclusive of the part that we agree to redact, should should be played, excuse me.
All right. Can you give me the time references, if you wouldn't mind?
So for the first portion, Your Honor, which is
Page 488 to 489, line 12.
yes, that will be approximately 5:33:55
2.
to 5:35, approximately 15.
Okay. And
This-
then the next portion, I believe, is page 489, line 14 to 489, line 24.
Yes, Your Honor, and that would be, I would say approximately 5:35:20
5:35:20
to approximately 5:35:32.
Okay. All right. And then the omitted part that you wished, you've agreed to take out in regards to Mr. Stillwell on page 490, lines 1 through 12. What is that?
I think, Your Honor, that's gonna be approximately 5:35, probably 40 to 5:36:13.
Okay. All right. And then 490, line 15, I think through the end. What does that go to?
So from 490, line 15 through, and this actually bleeds into what we just discussed that we agreed
491,
to.
line 10 or something like that. I think that was the end of the section that you were talking about.
Yeah, so that bleeds into, so we would start around 5:36:21. And that would be 490, 5:36:15, which would be 490, line 15. And that will go all the way through page 491, line 16, which would be 5:37:00.
Okay. All right. Mr. Adams, anything else before I rule?
Yeah, I want to address the foundation argument again. because Madam Prosecutor quoted from her direct examination of Mr. Copeland in asserting that they had laid the proper foundation to impeach him with the specifics of this statement. The last question that I heard after Mr. Copeland says, I blanked out, is where he's asked about whether in a phone call that he receives or in the car, and that's very specific, was there any discussion about Nutt's murder? Right?
That was on the stand.
Right, when
He was on the stand earlier.
Right.
Okay.
That's as far as the questioning goes in terms of any details. Right. Now, if you look at the transcript and if you listen to his statement, there's no indication as to the information that he's relaying that he got from Demikian or anyone else when he got that information. So I would agree. All right, I'm going to be as objective as I can here and say that if the state had gone further in their questioning, right, and say, okay, well, what about later on? Was there did you all meet anywhere? Did you all talk about this at any point after that? But they were very specific, and they ended the last question about what he knew about Nutt's murder was in a phone call or in the car. And so it is clear in my reading from the transcript that Mr. Copeland is referencing other conversations that take place at other times, and they can't simply say that, well, this is impeachment by contradiction based on, the answer to those two questions. And so I think that there's additional foundation that needs to be laid before they can simply carte blanche, just kind of throw this entire statement in there. Additionally, that's foundation argument. In regards to page 490, starting at line 15.
Yes, his baby's mom is not sister.
There you go. The entire conversation is what Nutt's sister, who is not a co-defendant, what her conversation is with Bentley, who is not a co-defendant. And to say that the reason we want that here, that is clearly hearsay. Copeland's relaying what he knows about a conversation between two other people, not even him. He's not party to that conversation. He hears about that conversation. So he's relaying what he heard there and the statements that are made by Nutt's sister and Bentley. And so it's clear that that's hearsay.
Can I stop you? I have just a question about that. Would that be that section where Mr. Copeland's talking about his baby's mom is Nutt's sister and that, would that go to effect on listener about what he did or what he said afterwards?
I don't think so.
Why not? I'm asking. I'm asking because I follow your argument about, and I'm looking at the transcript as well, and about what is being said, but why wouldn't that fall under that issue effect on listener where he's clearly talking about what the mother, the baby's mama, Nutt's sister, and what she told him, and then
and Bentley. Because here's why. Because the state points to one line on line 21 where it says that's why me and Bentley fell out. Well, there's no relevance to that. That doesn't have anything to do with his recitation of the information he has about Nutt's murder, right? Because those are the questions that are being asked, and he's relaying what he knows about Nutt's murder. And so for him to inject in there this conversation between Nutt's sister and Bentley, and what they said, and that's why he and Bentley fell out, because Bentley makes a statement about that conversation that doesn't really have anything to do with the information that's being relayed.
Okay, let me free. I'm gonna let you finish your argument, Mr. Adams. I want to ask the state's response as to what's the state's response as to that, basically 490 lines 15 through 22.
Yes, Your Honor.
What, because it is a hearsay statement from Copeland's relaying what Nutt's sister and Bentley told him.
So let's put it in further context. Bentley, the state alleges, is a co-conspirator in the YSL gang conspiracy.
He's an unindicted
He's
co-conspirator.
an unindicted co-conspirator. And Mr. Copeland has just reiterated Bentley's role in the murder of Donovan Thomas, that he is the place where both the car gets disposed of as well as the guns get disposed of. And so what he is saying to the police is, Bentley and I have now fallen out. Bentley and I are no longer friends, given what he is telling this woman about wanting to kill me when he knows I had nothing to do with this murder. And so we're not offering it for the truth of the matter asserted as to whether or not Bentley actually said, if you feel like he killed your brother, just let me know, one call that it's on. It is the effect that had on Mr. Copeland, and in turn, what he does with the information. He then confronts Bentley about it, but then he also asks Thug about it as well. And that is why, to put what he did with Thug into context, that the jury needs to understand what preceded that. Not that we're offering it for the truth of the matter asserted, but what preceded. But, excuse me. But what preceded why he was upset that Mr. Bentley would even mention that to his, Mr. Donovan Thomas's sister, and the fact that it upset him so much that he even mentioned it to Thug. Like, why would this co-conspirator say that he knows I have nothing to do with this murder? Why would he tell her that he would have me killed and he knows I have nothing to do with this murder? And so again, it's not being offered for the truth of the matter asserted, but it's being offered for the effect on the listener, being Mr. Copeland and what he did with that information. And I can't address the foundation issue again, Your Honor, regarding us getting this into evidence. So first things first, Mr. Copeland told the detectives that Little D told him about the murder once he got into the car. He began speaking about the murder once he got into the car. And then in his initial statement, he says that once Nard got into the car, they stopped talking. And then when Nard got out of the car, when they get to Sky House, they continued the conversation. So when I asked him in direct, was both, did you, Shannon, and Little D have any conversation about Nut being killed? And this is why they're in the car. He said, no. He said, I did not, which is inconsistent and in contradiction to what he told police. What he told police is, in the car, he told me about the murder. He told me about what happened. And so it is, the foundation has been laid for this to be answered.
All right, Mr. Adams, you can complete your argument. I thank you for allowing me to hijack you at that point.
No, I think I've done. I'm recounting what I recall from his direct testimony. I still don't think that there's been specific enough questions asked of him on direct such that what would be played in this would be impeachment by contradiction. And also, I've got to say, I reject the thought, going back a little bit to the other argument, that, Bentley's an unindicted, everyone's an unindicted co-conspirator. They hear the state tell it. If their name is referenced, they have some conversation about it. If they were around when something happened, they're an unindicted co-conspirator, and so their statements automatically come in. And I reject that. If they believe that Bentley was involved in the commission of Nutt's murder, they could have indicted him and charged him just as a co-defendant, as opposed to what they're arguing now as an unindicted co-conspirator. So I'm going to rest on all the arguments I made previously and ask you that these items be kept out. Be redacted.
Okay. All right, the court's had an opportunity to consider both arguments of counsels for the defense and for the state in regards to lines 488 line 1 to 491 line 10 and the corresponding video and audio marks that have been stated for the record already. In this particular period, talks or references where Mr. Copeland poorly talks about Nutt's murder based upon what he heard and what he thinks and what he finds from the defense's perspective, and their basis for their exclusion are hearsay, confrontation, speculation, lacks foundation. The state has responded by saying that they have in fact laid the foundation. They've also indicated that for a period of this where you have conversations in regards to what Mr. Garlington told Mr. Copeland, that those would be admissible under co-conspirator statements, which the court's ruled upon already. The other basis is prior inconsistent statements. The court is of the opinion that based upon what the court has heard from direct testimony, that in his direct, he says in pertinent summation that he doesn't remember what happened in the car, or he went blank, or words to that effect. Without having a transcript, I can't say the exact words, but the court is of the opinion that the state has asked a predicate foundation to explore from Mr. Copeland impeachment, at least impeachment by contradiction or prior inconsistent statements. So I'm going to omit those, allow the state to play that portion of the tape over a defense objection. Mr. Adams, I will give you and others a continuing objection.
Thank you.
And that does not include the omission of page 490, line 1 through 12. That's Mr. Stillwell's statement, which are going to be omitted by agreement by the state and Mr. Sharp. All right. Okay.
All right, yes, sir.
All right, let's move on to the next one, please.
The next one is, if we jump down to, is going to be page 499, line 14 through page 500, line 6. In those excerpts, if the court will take a look at it, the detective essentially, it's mostly the detective speaking. Mr. Copeland has a few lines in there as well, but it's mostly the detective speaking. And the detective is giving what I would define, what I would call a speech about how they want Mr. Williams, how Mr. Williams is using others for his, quote, their words, reign of power, and how Mr. Williams eliminates people or his enemies. His enemies is my verbiage. People is what the detective says. So if we look at line 14.
On page 499?
Page 499, yes, sir.
Okay.
The detective Dennis is talking. He says, you want to know what we want. We want the stuff to stop. If y'all were just making music, I like rap music. I like some of Thug's music. I think it actually says every now and then. Transcript says if he has any. Mr. Copeland just replies, yeah. Detective Dennis goes on and says, but that ain't what's going on. That's a fake card for indiscernible, all this other stuff. That's the detective talking, giving his opinion. Mr. Copeland responds, it didn't start until we got Thug. And then Detective Dennis responds, exactly. He basically used y'all as his gunners to help him get this reign of power. Nut, get out the way. You're a threat. Anybody that's a threat, he eliminates them. So at what point do y'all figure out that y'all can be eliminated too? He don't care about nobody but himself. What it sounds. Mr. Copeland says, oh, well, that's what it is. Detective Dennis says, so why would you stick around and let this man bring to your demise? So I'm going to go back to some things I say often. Sounds to me like, it seems to me that this is an easy one, right? The state is going to disagree. But this is Detective Dennis, none of this is relevant. The detective's thinking about, what Mr. Williams's music means or what type of person, what his character is absolutely not relevant. There's nothing that this adds to the case. There's nothing that this adds to any It's not an item of evidence. It's just the detective's opinion. Wherever he gets his opinion from, whatever he forms that opinion based upon, that's him. But it's not relevant. His opinion is not relevant. It touches upon Mr. Williams's character. It defines Mr. Williams' character in a way that is impermissible. And again, it's not based on any fact or evidence. It's based upon his opinion. And it's a commentary upon Mr. Williams's music and what it means, which again is the detective's opinion that has no relevance whatsoever for the jury's consideration. And so just based upon that, and of course doesn't give any foundation. I guess I'll throw that word in there, foundation for where the detective is getting this opinion, other than just that's what he thinks. His opinion is more prejudicial than probative. I would say it's not probative at all. And so I'd ask that it be redacted.
All right, Ms. Holton. All right,
Your Honor. Your Honor, the state will agree that beginning at line 23
of what page, ma'am?
of page 499 to page 6 of 500.
You mean page 6 of 500 or?
Page 500, line 6, I'm sorry. So page 499, beginning at line 23, where it says Detective Dennis, exactly, he basically used y'all as his gunners. Through page 500, line 6.
Okay, tell me why you think that I should,
The state has no objection to that portion being redacted.
the line 22 of page 499,
No, line 23
line 23
of
of,
page,
of page 499, so.
yes, through line 6 of page 500.
To page 500, line 6.
The state has no objection to redacting that portion.
Okay, let's talk about the I guess the rest, the from line
14 through 22.
Yes, ma'am.
Your Honor, in line 14 through 22, detective, well, let's go a few lines before this. Prior to this particular statement that Mr. Investigator Dennis says, they're still talking about Copeland's kind of concern still about being labeled a snitch. And who, he's in this space of, what do I do? If I tell, then the streets aren't going to like me. If I don't tell, this could happen to me. And what Detective Dennis says to him is, we want this stuff to stop. If y'all were just making music, he says, I like rap music. I like some of Thug's music every now and then. Copeland says, yeah, but that ain't what's going on. That's a fake card, all this other stuff. And then Copeland says, it didn't start until we got with Thug. This line is in direct contradiction to the defense's assertion in opening that the focus of their investigation was all about Young Thug and his music, that we attacked as the state, as the police officers, that we were only focused on using these lyrics and this music, and then we created a case solely based off of the music. And this is in direct contradiction to that. In the course of the investigation, the Investigator Dennis, is telling Mr. Copeland, this is not even about the music. Matter of fact, I like some of his music. This is about what has been happening in these streets, what the shootings that have been going back and forth for now, at this point, 6 months, and putting it into that. and encouraging Copeland to continue to tell the truth about what has happened. And then Copeland's response to that is, this didn't start until we got with Thug, until he, I believe, when the we is him, Demikian, and Shannon, that all of this violent stuff started happening. And it's not just about the music. And so we believe that this is in direct contradiction to the assertion that the police officers were solely focused on music and lyrics in this case, but no, they were focused on stopping crime and it had nothing to do with the music. So for those reasons, Your Honor, we believe that that portion is relevant.
Mr. Adams?
So the only thing that's, two things. Number one, I think we all know that what is said in opening
Not
and
evidence.
not evidence, questions by the attorneys aimed at getting at a certain point, not evidence. And so what they have to prove in court, they have to prove by way of evidence. What the detective says in this excerpt, and we're talking strictly about line 14 through line 22, this is the detective's opinion on what the music is or is not. So for example, if you look at line 19, when he says, but that ain't what's going on, that's a fake card for all this other stuff. Well, if that's the case, then let's prove it with evidence as opposed to giving the jury the detective's opinion as to what that is. Because without more, what the jury ends up getting is the detective's soliloquy on what he thinks the music means, whether or not it's being propagated for art, or whether or not it has something indeed to do with the rest of the case or any of the criminal activities that have been indicted. And they've got to prove that with evidence. I just don't think that there's anything here. I don't think number one, his opinion is not relevant in regards to this item of evidence. And I think there's a fair amount of speculation on the state's part. I've said it before. I understand they have their theory, but when Madam Prosecutor says that Mr. Copeland's response, it didn't, on line 22, it didn't start until we got Thug. When she opines, well, when he says we, he means Shannon and Demikian, and this is who he means. Well, they don't know that. They don't know that any more than we do, unless Mr. Copeland gets on the stand and says, hey, this is what I meant, and this is who I'm talking about. That hasn't happened yet. So that part is just speculation. But overall, these few lines that we're talking about is nothing other than the detective's speculation as to what he thinks the music is and his opinion, and that's not relevant and should not be allowed. Yes, one more.
May I add something?
Sure.
Also regarding this, the state is making the argument that this out-of-court statement should be played because of arguments that some defense counsel made during opening statements. My recollection is that certainly that Investigator Dennis has been on the stand, and he provided live testimony rebutting the defense argument about following lyrics, and instead said, no, we follow crime and then found lyrics. I believe that was Dennis. It may have been Gaither. Anyways, the state has provided live testimony regarding that issue and their counter to whatever was argued in opening that they say was argued in opening. So I don't know why we would, knowing that this has been argued through live testimony, I don't know why we would allow out-of-court statements, hearsay statements that also have problematic parts in speculation, as Mr. Adams has stated. I don't know why we would allow that into evidence when the state has already been allowed through live testimony to address this issue.
Okay.
And if I may just add very briefly, I also think that this is probably not necessary because, as I stated before, what's said in opening and the questions of the attorneys are not evidence.
But now the other thing I was going to mention, Mr. Sharp just reminded me, the court is very aware that you are not required to present any evidence at this point in time. You have not elected that decision, and that's of no consequence to me what they're saying you've said. You've said. So I'm not taking that from that vein at all.
Also true. And I do think it is, and I know it's been a long time because we did opening back in November or whenever it was.
Yeah, that was November, I think, yeah.
But I correctly what Mr. Steele said in opening. I do recall that he made reference to the state cherry picking lyrics and so forth. But again, so I think their recollection of that is incorrect. But I don't think that's part of the calculus or the consideration at all, because it's not in this.
Right,
You're right, so I have this problem about those last two.
sure.
So first, as it relates to the fact that the state cannot rebut what is said in opening, and looking at 24-6-621,
24-6.
621, which is impeachment by contradiction. Also in reading Carlson's on page 351, which is citing to federal law. Federal courts allow parties to counter misrepresentations and in an opponent's opening statement with contradictory proof.
What
This-
page is that? I'm sorry.
Page 351.
What part of the?
If you go to,
I see it. I
The
see it
third-
about the fourth paragraph down.
yes, Dan.
Okay.
And rebuttal will sometimes mean the countering of factual assertions made during defense counsel's opening statement or for them cross-examination of the government witnesses. So the state can bring in evidence to rebut what was said in an opening statement. But furthermore, Your Honor, this statement, what investigator Dennis said about the music is an adoptive admission by Mr. Copeland. Mr. Copeland does not disavow that this is just about making music. He, matter of fact, agrees with Detective Dennis. And in court, if you can recall, Your Honor, Mr. Copeland made it seem that YSL is just a music group. Matter of fact, I think he even said the only gang that he associates himself is 372, that he's not even a part of YSL. When I asked him directly, are you a part of YSL, the gang? And he disavowed that. So when you look at what he's testified into court about his disavowal of YSL, that YSL is just a music group, that this is in direct contradiction to that assertion. And he adopts what Detective Dennis says by not disavowing it, not saying, no, it's only about the music. He says, yeah. And matter of fact, he further says it didn't start until we got with Thug. So, Your Honor, for those additional reasons, we believe that this portion, page 499.
We got with Thug or we got Thug? That's what this transcript says. We got Thug.
I think it says, I think when you listen to the recording, it says until we got with Thug.
Let me listen to that portion, please. I just want to listen from about line 14 to line 22. Okay.
Yes,
Mr.
sir.
Sharp, you have something else?
Well, it just occurs to me that this adoptive admission argument,
Don't worry
I
about
mean,
that.
not only are
Don't
we,
worry about that.
okay,
Okay, don't worry about that. I mean, I'll let you complete your argument if you want, but I'm not convinced it's an adoptive admission, okay?
if you're not convinced,
All right.
good.
Okay, all right.
Let me attempt to convince the court also by just looking at 24-6-621. What it actually says is a witness.
Yeah, that's why I'm not convinced, okay? All right. Okay.
And Your Honor, I'm gonna start at page, excuse me, at time stamp
5:44:34,
30
33 to about what time?
to about 5:44:50.
Okay. Hold on.
They just like want to, they'll keep coming back telling them, I've been talking to the police, I've been talking to the police. And they just feel that ain't nobody locked up, everybody got no warrant. So I put it in their neck because they were the truth is everybody say, I can't just tell next or whatever I know, they get locked up. You know what I'm saying? Right. So they know that. And they ain't get locked up, so they know, well, I ain't tell. That's the only thing they keep me out of it.
But what happens when they start getting locked up?
So what I'm saying, that's why these
Started much Restart at 5:44.
I know.
You wanna know, we want the stuff to stop. If y'all was just making music, I like rap music. I like some thug music every now and then.
Yeah.
But that ain't what's going on. That's a fake card for fueling all this other stuff.
It didn't start till we got sued.
Exactly.
Yeah.
One more time, please. Christina? Anybody else who wants to listen to it, you're welcome to come up and listen as well. What? Not yet, not yet. I'm almost ready.
Fish. That's not to insult you. That's being real. Like,
I know.
you wanna know, we want the stuff to stop. If y'all was just making music, I like rap music. I like some thug music every now and then.
Yeah.
But that ain't what's going on. That's a fake card for fueling all this other stuff.
It didn't start till we got sued.
Exactly.
Yeah.
Okay. Detective Dennis on lines 14 through 16, part of it is, I like some of Thug's music now and then, or to that effect. It's not if he has any. And then on line 22 of 499, it does say when it didn't start till we got with Thug.
But what does that mean?
I don't know. I'm just listening to it. Okay, so Jenny, you want to listen to it as well? I mean, I'll give you the opportunity. Give the opportunity to do so.
I don't disagree that, what's in the transcript is.
It's not quite accurate. It's close in regards to that particular portion of what Detective Den starts off with. Okay. All right. Based upon the court's listening to this particular portion of lines 14 through 22, the court is of the opinion that it is opinion by Detective Dennis and it is speculation. So I'm going to exclude it at this time and omit it. Just that particular section.
Thank you, Your
All
Honor.
right.
Can you give me the timestamps starting at line 14, line 6?
So it should be 5:44 at 34.
You said it was 29 earlier.
Well,
I think-
I started at 23, so I'm going to say 5:44, 29 approximately to 5:45,
28.
23.
5:44, 29 to 5:45, 23.
Yes.
Okay. Any further argument or discussion in regards to that portion? Okay. All right.
Next one, on the last page, sent to the court.
Hang tight 1 second. All right, sir, I'm with you.
Yes, sir.
Is it 523?
Yes, 510, line 4 to page 511, line 3.
Okay, 510, page, line 4.
Yes, sir, to page 511, line 3.
Okay,
That's a conversation between the detective and Mr. Copeland Essentially what they're doing is they're talking about who to go after first. And there's some opinion as to who they should go after first, opinion about Shannon, opinion about D, and opinion about Doo-Wop. In relevant part, I'm gonna just kind of read through from line 4. Detective Thorpe is speaking, and he says, so let me ask you this, of all them, I think he said clowns, of all them clowns you just named, who do you think the first person I should go after? Ms. Copeland responds, to lock up or to talk to? Talk to. I would say Doo-Wop, but if you go after him first, they're gonna have a feeling somebody told. You feel me? That's an opinion. Detective Thorpe, so who you think I should go after first? Mr. Copeland says, B, truth be told, I want to say Shannon. You feel me? Because when he said this indiscernible, I think it says got locked up. Because when we got locked up, Shannon looked like he wanted to tell. You know what I mean? Tell on them. Again, an opinion, speculation on the part of Mr. Copeland. Detective 1, yeah, but that was years ago. How you feel about little D? Like, since D was the one that supposedly wasn't shooting, but he came and told you. Ms. Copeland says, D thinks he's hard. It's his opinion. Detective 1, so he probably wouldn't just because he thinks he's hard. Mr. Copeland says, right, when I gave him your number and then y'all let me go, I was looking at him like, damn D, like he the one, he knows I gave him your number, bruh. You ain't have to go tell everybody. Detective says, right. Ms. Copeland says, you know what I'm saying? Like he indiscernible on me. That's a little further. I think it stops at line 3. But it's clear that whole colloquy from the previous page, 510 to 511, is all a matter of speculation. What the detective is asking Mr. Copeland as to who they should go after first, either to talk to or to arrest, there's no way that there's any relevance to that. Mr. Copeland's opinion, speculation as to who might talk or who might not, regardless of what he knows about those individuals, is in fact speculation, it's opinion, and it's not relevant. So my objection to that colloquy on that page and a few lines would be that it is improper speculation, impermissible speculation, and irrelevant opinion, and it should be redacted. It simply has no relevance whatsoever.
All right, sir. State.
Yes, Your Honor. Your Honor, this is very relevant. Again, the defense's theory about this case is that they didn't do any investigation. They didn't do anything. All they did was take what Copeland said and ran with it. And what this shows is that the detectives were trying to speak to other individuals in order to corroborate what Copeland told them. And so they are asking Mr. Copeland his lay opinion on who out of these individuals he should talk to. So I know we keep throwing around the word speculation and opinion, but a lay witness can give their opinion if that opinion is rationally based on the perception of the witness, which is 24-7-701. Mr. Copeland knows the individuals to whom he's been talking about. He has spent time with them. He is friends with them. He considers some of them like his brothers. We have pictures of them together. So he can, based upon his own opinion, can say, this is who I think will talk to you all, based upon his interactions and his lay opinion, Your Honor. So the fact that he tells them, here's who I think you should talk to, here's who I think will talk to you, is a proper opinion that he can give. And it's clear that it's an opinion because he talks about Doo-Wop versus Shannon versus Demikian. And he tells them, here's who I think you should go to first. But if you go to this person first, they're going to know that I told something.
Can I ask you a question?
Yes.
I'll hijack you just for a second.
Sure.
Did you ask Mr. Copeland about this on direct already?
Ask Mr. Copeland
On direct about any of about any of his discussions with Detective Dennis in regards to this part of the investigation? I don't recall it being asked.
About if he told the detectives who he should speak with
Yes.
in regarding this case. No, I don't believe I asked him
Okay.
directly that specific
All
question.
right, I'm gonna exclude it for foundation right now. I'm not saying it may not be admissible for other reasons later, but I agree with Mr. Adams. It is speculation and opinion is not relevant under 401 at this point in time. However, having said that, if somebody opens the door as to it, or if you continuing with your direct examination lay a foundation as to ask him any about that, then I'll reconsider.
So I guess my question is, if I ask him, did you advise law enforcement who they should speak to? There's going to be a lay opinion objection. When I'm saying it's not a lay opinion. If
Well,
he
it
knows-
still might be speculation or opinion because it's got to be based on something. You're saying it's based upon he knows these people
Right.
and he's got them, but you'd have to lay the foundation to ask that question.
But I think we have laid the foundation, or we've
No,
established.
here's the thing. I don't think you get covered because he says, I don't recall, or I don't remember. I think you still got it, as I mentioned to you yesterday. With all due respect, you still got it, since you haven't asked him about it yet. It wouldn't be proper to just play this.
What-
However, if you can lay the foundation based upon the argument you just told me, I'll certainly consider it at that point.
And I guess I want clarity because I think we've laid the foundation that he would have a proper basis to give a lay opinion.
I
So
don't know.
we believe that.
I need to, again, if you lay foundation as to a lay opinion, I might be able to rule upon it. I don't know whether or not that will carry the day or not, but it depends on how you ask Mr. Copeland those questions and his response. Like I told you, I'm not saying that it may not be, but not right now.
All right.
So I'm gonna exclude that for the time being for foundation, but in the arguments of Mr. Adams, and like I said, I'll come back to it if you remind me at the appropriate time, and we'll look at it. Okay. All right. And, yes.
That is going to be 5:54:22
5:54:22.
through
5:55.
5:55:19.
5:55:19. All right, any further discussion? Okay.
The last one, Judge, is page 512, line 18, to page 517, line 19.
And Your Honor, based on your previous ruling, I think that this covers that same area about who they should speak to. So given your current ruling,
Okay.
the state will just address it at that.
Let me have
specific
the time. Let's have the time markings as well. So that will be excluded for foundation as well at this time.
And that was going to be the same one.
Okay. All right.
5:56:18
5:56:18.
through 6 o'clock in 3 seconds.
So what is that?
6:00.
6:00.
03.
Okay. All right.
That's it, Judge. That's all that we have on behalf of Mr. Williams.
Okay. Before I return to Mr. Sharp for the two ones that we may have, and I think I asked the state about those. So let me get to that place and let me get to it. Part, and I think that there's two that we may need to discuss or talk about again in regards to your client, Mr. Stillwell. Mr. Weinstein, anything else in regards to June 10th interview? All right. Mr. Matthews Jr., anything else in regards to June 10th? Okay, and good morning, sir. All right, Misty Williams. All right, Mr. Botts, on behalf of Mr. Nichols, all right. Okay. Anything further? Now I'll turn to Mr. Shark.
Yes, sir.
I think that you were going to take a look at your notes or whatever in regards to for two particular areas. So have you done that so far, sir?
Well, I think we tabled it to, I don't know if I was necessarily going to look at my notes, but I've given those issues some thought, but I think we tabled them for further discussion.
Are you going to wait until they're played to object, or do you want to, can you identify them for me so I can rule upon them?
I have them, Your Honor.
Okay.
I believe it was,
Tell us what the page reference was, Ms. Hilton.
I think it's page 361.
That's one, line 1 to 362, line 10.
No, I have line 15 through 17, Your Honor.
That's the one where I think it's problem is Shannon. Is that correct?
Yes, and
All
I
right.
believe the court wanted me to go back and listen to and determine if I asked questions.
Yes. And, all right. That was one. Okay. And did you review that, madam?
Yes, Your Honor, and that's consistent with the portion of the transcript that I just recounted in the argument with Mr. Adams about when Shannon got into the vehicle. Again, Mr. Copeland's current version of facts on the stand is that Shannon got into the vehicle with him and little D at the McDonald's.
All right. Let me take a look at that right quick again.
This is regarding page 361.
Yes, line 15 through 17. And I believe the portion that's at issue is where he says Shannon shot Nut is what the court wanted to hear if I had asked him questions about the murder of Donovan Thomas.
Can I just go back and make sure we're on the same page with everything leading up to this? Because, Your Honor, I too, I know what Ms. Hilton's speaking of, but I also had in my notes 361 through 10. So can I just confirm?
361 line 1 through 362 line 10.
361 line 10 to 362 line 10.
Okay, I originally had line 1. All right, so okay.
So 361 line 1 through 12, we'll say, the state has agreed that that's coming out. Is that correct?
No,
Okay, so all of this is in dispute, right?
no. From what you gave us originally, the only thing that was in dispute was Shannon shot up Lil Wayne's tour bus. Shannon shot Nut. Shannon does whatever Thug says. So that was
on my list. It says page 361, line 1 to 362, line 10.
All right, so is the state agreeing to a portion of this to be redacted, or what are you saying?
the only portion that we agreed to be redacted is on line 16. Shannon shot up that tour bus.
Okay.
Line 16, and that's on page what, madam?
Page 361,
All right, and
and it says the specific sentence is Shannon shot up that tour bus. And I believe, Your Honor, on Monday, you were holding off ruling to determine whether or not I had asked Mr. Copeland about the murder of Donovan Thomas. And you wanted me to confirm with Madam Court Reporter that I did ask Mr. Copeland while on the stand about the night of Donovan Thomas's murder.
All right. Specifically, what did you ask him? Because I do recall you did ask him about that, but remember, it's consistent with my earlier statements, that what exactly did you, because this particular, let me just kind of. All right.
Yes, so do you mind if I keep my seat, Your Honor?
Yes, ma'am, you can keep your seat, just as long as you speak in the microphone, that's fine.
Yes. So it starts after you left Mechanicsville. Did you go anywhere after leaving Mechanicsville from what you remember? Yeah. His response, yeah. Question, do you remember where you went?
This is your examination.
Yes, Your Honor.
Okay, all right.
Pick little D up. Question, okay, and which little D are we talking about? Answer, the one that always be with me. Is that the little D you referenced as your son? Yeah. Okay, do you remember where you picked little D up? Where did you pick little D up at? Answer, at McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to the McDonald's on Cleveland Avenue, was there anyone else with little D? Answer, just him and Shannon. Anybody else? Just him. It says have Shannon, but just him have Shannon. When you picked up little D, what did Shannon do? What you mean? You said you picked little D up. Did you also pick up Shannon? I said I picked up both of them. Okay. When you picked up both of them, where did you all go? I blanked out after that. You blanked out after that? Why did you blank out? Because they were saying that I got phone calls saying I did something. Do you remember who called you? Yes. Who? Munson. And do you recall how he called you? Did he call you on FaceTime or did he call you on the phone? I don't know. He asked me what I got going on or if I heard what happened or what. I don't know what he said. I just know he said that. I mean, people saying I killed Nut and he was calling me. Now, let me ask you this. Did you kill Nut? Huh? Did you kill Nut? No. Okay, now when Munson called you, was both Shannon and Little D in the car when Munson called you? Huh? Was Shannon and Little D in the car when Munson called you? I think so. Now, before Munson called you, did you, Shannon, and Little D have any conversation about Nut being killed? No. Now, after you got off the phone with Munson, did you and Shannon and Little D go anywhere? Huh? You said you were on the phone with Munson in the car. I blanked out. Like, I know I ended up in a whole lot of places. Every time I looked around, I was somewhere different. Okay, later that evening, as we talked earlier, did you go to the police department? No. That night that you learned about Nut's death, Munson called you. At any point, did you go to the police department? Oh, yeah. And then I believe at that point, Mr. Steele may have objected. And then I go into, on the morning of January 11th, did you ever speak with police? There was another objection. I asked the question again on the morning of January 11th, did you ever speak with police about Nut being killed? The police called me. Did you go to the police department? Same objection. Did you go to the police department, speak to the police? Yeah, I think I asked them, how did you get to the police department? I dropped him off. By who Munson got me, I ain't for sure. I can't recall. But I think who dropped me off, I just remember my brother and then met me down there that night. I said, now, Mr. Copeland, today being June 13, 2024, prior to today, I want to make sure I understand. Have you ever told police that Little D and Shannon got into your vehicle? Mr. Steele objected. The objection was sustained. Is today the first time you told the police or told anyone? And then the court interjects at which day? Today, June 13th. Let me strike that. Yesterday, did you tell me and my colleagues that Shannon, objection leading? I'm going to overrule the objection. Yesterday, did you tell myself and my colleagues, Ms. Love and others, about Little D and Shannon being in your vehicle the night of the murder? Huh? Yesterday, did you tell myself, Ms. Love, and a few of my other colleagues that Little D and Shannon were in the car with you the night of Donovan Thomas' murder? I told you and them that what I told the investigators when Nut got killed, something different, because I was trying to finesse my way out of the situation. Okay. So I said, I picked up D and Shannon. D never told me nothing. I made it up to clear myself up, and that's it. Okay, and was that yesterday that you said that? Did you tell us that yesterday, what you just said? You asked me to be truthful. So, again, anything that, and that's the end of the transcript as we have it. So again, he told me in court that D never told him anything, nothing. So anything that D told him back, that he told police D told him would be impeachment by prior inconsistent statement, impeachment by contradiction. He said, I made it up to clear myself and that's it.
You sure?
That's not true. The state's skipping a step. First of all, impeachment by contradiction is bringing in, it's not supposed to be prior inconsistent statements. That is.
No, it's anything that the witness testifies inconsistently with earlier. I mean,
Well,
so
respectfully, that's what prior inconsistent statements are.
it can be,
Contradiction, Your Honor, is witness named Jeff says the light was red at the time of the crash. You bring in witness Brian that says, no, the light was actually green at the time of the crash. That's impeachment by contradiction. You bring in another witness to testify about how the first witness was incorrect or wrong or contradicting. Prior inconsistent statements is a type of impeachment contradiction using a witness's prior statements. And so what the state is missing here is they're saying, did Demekian, they're saying the foundation is laid by saying, did Demekian, was Demekian in the car? Did Demekian say anything? Kenneth Copeland is saying no. But that's not the correct question to lay the foundation for prior inconsistent statements. They need to say very specifically, they need to ask, did you tell police that Demekian Garlington told you this on this date? That lays the foundation. And they're also confusing the issue by including Shannon in these conversations, which has never been said by Mr. Copeland. So if they say, did Demekian and Shannon, did you tell the police that Demekian and Shannon told you that so-and-so, whatever happened on January 10, 2015, he would be correct to say, no, I never told the police that. And there would be nothing inconsistent because he has never put Shannon as a party to any of these conversations. They need to specifically ask, did you tell the police, not did it happen, but did you tell the police that Demekian Garlington told you this? And if he says yes, then they don't get to get in these prior statements because they're not inconsistent. The question isn't, did Demekian tell you this? It's, did you tell the police Demekian told you this? And if he's asked that question, he may very well say, yes, I did tell Demekian that. It was all I did tell the police that Demekian told me that. It was all a lie, but I do acknowledge telling the police that. In which case, there's no prior inconsistent statement because he is acknowledging that he made that statement in the past, and it doesn't need to be proven using extrinsic evidence, including a videotape. But they haven't done that. They've just asked did it happen, not did he tell the police that it happened.
what if, as in this particular circumstance, I think that there's an omission. Like he says, hey, I don't recall this, and then his earlier statement says, includes more people or is more or has more granularity.
Well, the problem is they asked, did Demekian and Shannon discuss this in the car? And he has never said Demekian and Shannon discussed anything in the car. He said, what he said in his prior statements were, I showed it at the McDonald's. Demekian was the first person to come to my car. Demekian got in my car, said something very quick, pointed at the people who he said did it, and then didn't say anything else. That's what he said. He never said Shannon Stillwell was in a car discussing anything. And the reason he never said it because Shannon Stillwell was never in a car discussing it. So be very specific about what they're saying he said in the past. And if he owns that prior statement, then this doesn't get in.
All right.
Your Honor, but that's the point, Your Honor. We agree. He never told the police that Shannon was in the car. So he is contradicted by what he told the police previously. And he said, and I don't have to ask him again, His answer was, I told you and them that what I told investigators when Nut got killed, something different because I was trying to finesse my way out of the situation. He has already admitted right there that what I said to the detectives in 2015 is a lie. It's not true. I finessed my way. And it's inconsistent with what he is now saying in what he said back then. So that's a prior inconsistent statement. Furthermore, to address what Mr. Shar just said about extrinsic evidence, when it comes to impeachment by contradiction, impeachment by contradiction occurs when a party offers evidence to prove that a fact to which a witness testified is not true. And it can be done by extrinsic evidence. The recording is the extrinsic evidence that we can bring in to show that what he said in court is not true. This is the extrinsic evidence. It does not have to be another person. The law does not say you have to bring in another witness. I can bring in extrinsic evidence. That is the recording of him in the interview room telling the police what he said.
All right. Mr. Short, I'm gonna admit or allow the state to play that particular portion from page 361, line 10 through 362, line 10, as impeachment by contradiction. I'll give you a over defense objection. I'll give you a continuing objection as to that, sir.
Minus the,
Of course, minus the 361, line 16, Shannon shot up that tour bus. That will be excluded.
what about?
Before you go on, can you give me the time reference, madam? Time, video and audio time.
So for the portion that is out is 3:29:37 to 3:29:39.
Okay. And the balance is from what time to what time, exclusive of those, at that time period?
So it'll start from 3:29:20 through 3:29. It will probably stop at 36 to make sure that we do not get into
Okay.
the middle part, and then it will pick back up again at 3:29:41.
All right. Mr. Short, anything, you were going to mention something else, sir?
And I understand your ruling as it applies. I respectfully disagree, though not waiving
Sure.
objections, but I understand what you're saying about he shot the gun and killed Nut. I don't understand how on the theory of impeachment by contradiction or prior inconsistent statement, how this part gets it. Thug, this is Kenneth Copeland. Man, whatever Thug say to these ends, Shannon will do it, man. Every time Thug say something, Shannon do it. Like now, if they want to get into the Bloody J thing again, I don't think he's denied anything with the Bloody J. I don't think he's testified to anything different about the Bloody J. He said Bloody J was beaten up. So I say that and beat him up. So those statements, I get what the state's arguing about the killed Nut. But those other statements, they're just bad character, generalizations, not inconsistent with anything he's testified to on the stand, not inconsistent with anything that he's been confronted with on the stand.
It's the respectfully, it's the conversation in the car that the jury decides whether or not they believe it or not, whether or not the version that they believe was the one that was done on the 10th of January of 2015, or on the stand on or about January June the 10th of 2024. I think it's impeachment for what he didn't tell them in the car. Well, one, that he wasn't there, or two, what he said in the car. So I think that's what the impeachment's for.
But when he says, like, man, whatever thugs say to these ends, Shannon will do it, man. Every time thugs say something, Shannon do it. That's not anything that was discussed in a car.
State.
Your Honor, so two things as to relate to that portion. We have charged Mr. Williams with a leadership charge. So this directly goes to the fact that anything that the leader says, Shannon does. So that directly addresses the leadership charge that we have charged Mr. Williams with in this indictment. Furthermore, Your Honor, again, when Mr. Copeland has said everything that I told investigators regarding the night of the murder, regarding anything I told them, I was telling them anything to finesse my way out of going to jail. This would be in contradiction to that because he's saying that's a lie. Now, if the court would like, and I have no objection to asking him specifically, does Shannon do anything that Mr. Williams says, and then playing this portion, I have no objection to doing that. But it is important because we have charged Mr. Williams with the leadership game count in this indictment.
It's all speculation, and I understand that the state
Well-
feels it's relevant because they've named that Mr. Williams. They've asserted that Mr. Williams is somehow a puppet master over everyone, which isn't true. But beyond that, just because they've asserted it doesn't mean all types of everything is admissible. It still has to be based on personal knowledge. It can't be speculation. And so, yes, they're asserting, okay, it's relevant because this is the way we charge the case, but that doesn't solve all the other evidentiary issues with it. And again, we're not even talking about something that the man's saying on the stand. We're talking about it being played in a tape, out of court statements. So just because the state has indicted something a certain way doesn't mean they just get to play a bunch of tapes that fit their narrative.
Yes, sir. I'm still going to admit it for its purpose. Over your objection, I'll give you a continuing objection, sir, as to that respect.
Yes, Your Honor.
All right. We have one more, madam.
Yes, Your Honor, and that was for page 386, line 20.
386. Hold on one second. Let me see if I can find it. Okay, you said 386
Yes, Your Honor.
line. I'm sorry, line 2.
Page 387, line 12.
Okay.
And Your Honor, I believe this is, Mr. Copeland was discussing the conversation that he had with Nutt prior to Kel. The discussion that Mr. Copeland had with Mr. Donovan Thomas Jr. regarding Mr. Copeland's differences with Shell Kel or Kelvin Watts. And the court wanted to know specifically if I had asked Mr. Copeland any questions about whether or not he had ever spoken to Nutt. And we were able to find in the transcript that I did ask him a specific question, and I can read that portion to the court.
All right, go ahead. What did you ask him?
So it starts with, do you recall telling Detective Thorpe that Nutt was somebody you could talk to? I don't know nothing about all that. Okay. Do you remember? I don't know. Yes, I said it to him. I don't know. Do you remember telling Detective Thorpe about the last conversation that you had with Nutt? I had a conversation with Nutt. Do you remember telling Detective Thorpe about a conversation that you had with Nutt? I don't remember what I told Detective Thorpe. Do you remember telling Detective Thorpe that when you saw Nutt, he just told you to chill out and just And then there was an objection by Mr. Steele. He said hearsay. Court sustained the objection. I responded, it's going to be effect on the listener. It's going to be what his response was. Judge then overruled the objection. And then I asked him that you told none, I'm just trying to get money. Was I supposed to say that to the police? Yes, I told the police. Excuse me. I said, you told the police. He says, yes, I said it. So that was your last conversation with Nut? I guess, yes, I don't know. When you say you don't know, what do you mean? I don't remember what I told any police. I don't remember what I have told them. And Your Honor, this portion right here, when he says, I don't remember what I told them, it really opens the door to all of his statements coming in without me going in line by line. However, you know, the state has gone back, but the case that I cited to the court yesterday, which I think was the Scudder's case.
Scudder case.
In which once
Scaniers versus the state.
Scaniers
318 Georgia 855 decided April of 2024.
Yes, Your Honor. And once he says, I don't remember anything I told the police, I do not have to go line by line to asking specific questions.
Not saying you have to do that. Not saying you have to do that. But I don't think it gives you carte blanche, as I mentioned yesterday. So does your question, does your questioning again indicate questioning in regards to Kel or Mr. Stillwell?
This line of questioning discusses speaking to.
On the and let me be clear. From what Mr. Copeland was on the stand earlier, what did you ask him that on the stand when he was here several days ago that opens the door or allows you to play this particular part of the tape?
And this, it's not contained in this, what I have as a transcript, but I believe when I continue my questioning, I asked him specifically about talking to Kel. Now, I will take responsibility. I did not ask Ms. Weaver to give me the rest of this portion of the transcript, just solely the fact that
why don't I defer on it again until that'll be an outstanding one. You just need we will hold that.
Can I just clarify?
We'll hold that until the transcript is at least a little bit more readily available.
Can I clarify our stance, though, just so?
I'm sorry?
Can I clarify our stance to kind of crystallize the issue?
In terms of what, sir?
Well, the state is asserting that they've established a foundation to get into either impeachment by contradiction or prior inconsistent statements.
Well, not yet, Mr. Sharp. I'm going to defer on that until I hear whether or not they have in fact asked enough for me to even entertain this particular set part of the transcript.
That's what they're asserting. But just because they ask about
No. I agree with you. Okay, at this point. Well, I need to hear the statement first that was asked on the stand to make that determination. So that's why I'm saying let's defer it until that time, because I need to first hear what was asked, hear what his response allegedly was, and then determine whether or not it falls within an acceptable, if it does, exception for me to authorize them to play it.
Yes, sir.
Okay. All right. So just remind me, I'm going to hold that. Okay. All right. All right, councilors, is there anything else in respect to any of the interviews involving Mr. Copeland as it pertains to interviews on January the 28th, 2015, February the 21st of 2015, or June the 10th of 2015, other than the one I've held?
No, Your Honor, and the state's intention is to take the transcripts that we have, highlight the redacted portions, send that over to defense counsel so they can confirm.
I'm just going to say that you will be doing that the Thursday the 27th, and Friday the 28th. Okay, because I do want to make sure you all have a chance to look at that. Please don't come here and we get Mr. Copeland back on the stand, and then you all want to still argue about redactions that. So I want to know if there are any problems before we put him back on the stand or we resolve those. So yes, showing those. So defense counsel, is that acceptable to you?
Can I give it to them by Sunday? Only because, Your Honor, as the court may be aware, we have a full day of court with the other individuals on Friday. And so I'm going
What's
to work.
this Friday?
Yeah.
No, we're not. here
No,
this
not
Friday.
with the
Oh,
other.
okay, yeah, that doesn't pertain to me. All right, so right now.
But it
Okay, one of
pertains to the members of
one
the
of my
state.
one of my other colleagues. Okay, all right.
Yeah, so we
Okay.
can have it until this weekend. We do intend to get it to them by no later than Sunday.
At what time?
Sunday by 5.
My suggestion is that, and you all can do this the way you want to, but you all need to probably look at this. You know, you probably need to play it,
Yes.
or at least the portions I've ruled upon. You all need to get together physically or have a representative get together and go ahead and make sure that the edits are correct. Because what I don't want to do is play things that are outside the bounds of what we talked about, and then there to be objections and problems. So can I get somebody's commitment to do that? And if so, when are you going to do that?
We can do that tomorrow, like just to sit through and run through the times. We can do
All
that,
right.
and then the redaction, like with the actual transcript, I can get that.
All right, so defense counsels, are you okay with that suggestion? Well, who's gonna, or
So objecting to the.
just generally, Mr. Steele, I know that you don't believe a foundation's been laid and you believe that it is improper impeachment as a whole. So that is not lost, and that'll be your overarching objection, which I'm giving you and others a continuing objection for. But since I've ruled, to the extent that I've ruled on the parts that need to be omitted, that's what I'd like you all to at least make sure that occurs.
As far as I'm concerned, Sunday is fine. That's what the state asked for.
Okay. Is that for the transcript, or are you all going to actually physically get together and look at the video and audio to make sure it matches?
Can I ask, is the state planning on taking segments out so it jumps from one to the next, or is the state envisioning just turning the volume off?
We'll turn the volume off only because when we tried to convert it, and I think you all had the similar issue, it jumps. The video itself is not it's not good video. Unfortunately, when we try to convert the evidence reviewer to MP4s, it doesn't. It's not good video.
Okay.
To do that. So we can plan to play and stop. Now we can, if defense counsel on their own wants to verify the times, and then we can verify the times, just make sure that the times are consistent. We can do that as well. If they would do that on their own and they can just forward us the times, we can do that as well. But we're open to whatever way to make sure that we don't have any issues.
Okay. And Mr. Steele, you said or Ms. Sharp?
Speaking for myself and I think others, we don't know the technology involved, but we object to presenting it, just playing it and then turning off the volume for certain segments and then turning the volume back on. I think that invites the jurors to believe that something's being hidden from them, invites them to assume that it's they're not getting evidence concerning our clients, and invites them to draw negative inferences from that. So we would object to just turning off the volume and letting the video play. I'm not sure about the technological challenges. Someone that's smarter than me, I'm sure can find a way around that, but that's our stance.
Right, I think the court will instruct the jurors that they are only to consider admissible evidence. And so what the court has ruled or deems that portions are not admissible or that the state doesn't intend to play it. And there are portions that the state doesn't intend to play that defense counsel may or may not play. And so if we redact portions and make it seem as if there's one interview, the jury may get confused if there's a portion that the state redacted that now becomes a part of evidence when the defense decides to play portions if they choose to play it. We've already been doing this in this method. This has not changed. It's nothing different than what we've already been doing.
Okay. Mr. Shard, I've noted your objection for the purposes of redaction. I'll just, at this point in time, given what we've done earlier and the challenges that we've had, we'll just turn the sound off at that particular period. And we'll do the best we can with that. All right, anything else? Okay, as it pertains to those 3 interviews. Okay, because Mr. Weinstein's got that look again. We're gonna go ahead and recess for a break and for lunch. Let's come back, councils, at about, let's just say 1:15, and we can go ahead at that point in time and take up the jail calls that that Ms. Hilton has, we'll identify the email, take up the jail calls that she plans or that the state plans to play at this point in time. And we'll see where the day leads us at that point, okay? All right, I'll see y'all at 1:15, all right? We're in recess.
Really? 100 million bucks is a pretty good.
subsequently released under Mayorkas. By the way, he was covered in gang tattoos. They knew exactly what he was, but Secretary Mayorkas's his leadership, these
the jail calls that are that the state wishes to play at some point in time during Mr. Copeland's examination. I'm going to include as the next court exhibit in order the email sent from Ms. Hilton to all of you on Tuesday, June 25th at 7:54 p.m. All right, so Ms. Hilton, from your email, it looks like that there are 5 calls that you wish to, you initially provided 11 calls, but these are the 5 calls that you are definitely going to play, and the other 6 may become relevant at a later time. And that you say during your email, these do not cover jail calls that you intend to introduce to other witnesses later in the trial. So
Yes.
these are just the ones most immediate that you believe you're going to use to continue with your examination with Mr. Copeland. Is that correct?
Yes, Your Honor.
Okay, all right. So given that backdrop, I think the first one that you indicate that you are going to play is, you have it marked as Index 58, March 11, 2015 at 19:27. And it goes from 00 to about 15 minutes and 30 seconds. Is that about right?
Yes, Your Honor. At this juncture, we haven't heard any objections from the defense.
Well, first, let me find out. Do we have any spokesman, or do you want me to ask each individual defendant? Yes, sir. Okay. Of Index 1, I'm using Ms. Hilton's email for purposes of this discussion.
And Your Honor, it will be State's Exhibit 401.
I was going to ask you that
Yankee.
next. Okay, it'll be States 401 Yankee.
Yes, Your Honor.
And Mr. Steele, what's the part that you have an objection to?
Mr. Copeland is asking for a lawyer. I believe the state alleges that he's speaking with Mr. Jeffrey Williams for part of that call at about that time, and that Mr. Williams uses my name, my first name, on the call. I would object and ask to redact that portion, especially my name.
Okay.
Your Honor, and listen to that call, I don't believe he said Brian.
Can you
And
play
we'll
it?
play. What's the time?
Can you play
stamp?
maybe play the last 2 minutes? Would that be sufficient for me to listen to it, Mr. Steele?
Yes, sir.
Okay. Let's play the like 13:30 to the end.
Okay.
Okay, of 15:30. Oh, thank you. Thank you.
Oh, sorry, that's not the right one.
Say what?
You go.
13:50. Okay.
Look in your eyes. Yeah, they say.
Your Honor, we're gonna start at 13:30 or 13:33 now.
All right.
The police, let them jump on me. I see Nick crazy, man. Man, it's whoever has so many problems. Whoever in the jail, all that jumping, that's right there, man. Right there, man. This shit here, dread, bro.
Man, what the hell you talking about? You already know I know. You already know I know what's happening. Some of y'all locked up. I was already like, what the hell? What they talking about? Now I'm talking about nobody. That's what I'm trying to tell you. Man, I don't stop right in front of these folks and look at these folks call that shit on the phone. Yeah. I made Bentley call her. Like, call her. See what the fuck going on. Because of probation. That's just a little bullshit. But the probation will try to hold you. Just about their money or whatever. So I already know that. I just said, I would just gave him a lawyer, a 3-4 band, $2,500. You know, he'll bring you. You have 1 minute left. He'll get you in the courtroom for $2,500. You know, that ain't shit.
I don't even want that much. One lawyer had so.
I know.
Yeah. So listen, I might have this son text you my information and stuff. You say you try to have it in the morning.
Yeah, I had a lawyer or whatever lawyer you choose.
I don't have none.
Well, I could just have somebody pull up on their son and bring their son the money. Then you see what I'm saying, or they son, mom or daddy, because you know they probably know something about the shit. So I can just make anybody go get the money. I can make them pull up to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure.
Shit, we don't know no lawyer though.
Yeah, that's what I'm saying. You know my lawyer.
So you?
I know mine. I ain't got the number. Hit him. You just tell him. Like, yeah, he already got my card and everything. He already got my card and his system and shit. So I ain't got the number. Just hit him. Like, go check on this number right here, and then go check on his name. And
Thank you for using Securus. Goodbye.
I did not hear Brian or Mr. Steele's name at all.
Mr. Steele, I can't say I've heard it either. Do you have a time reference you can point me to again? I'll listen to it again.
Very 15:12 is what I'm being told.
Okay, let's play about right at 15 minutes, please.
Hello.
Oh. Chris, can I listen to this too? Okay, all right. Council, I'm going to listen to it through the ear audio system. You're welcome to listen to it as well again.
It's going to start at 15:04.
Go to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure.
Shit, we don't know no lawyer though.
Yeah, that's what I'm saying. You know my lawyer.
So you?
I know mine. I ain't got the number. Hit him. Just tell him. He already got my card and everything. He already got my card and his system and shit. So I ain't got the number. Just hit him. Like,
you can stop it. It
go
does
check on this number right here and go check.
So.
That's fine. We can stop it right before that portion.
All right. Mr. Steele, any further? They're going to edit. They're going to not play that. I do hear your name. At least what's represented to be Brian. So that will be excluded. Does anybody else have any specific objections as to any other period of that call from 000 to 15? About 15 minutes, 10 seconds or thereafter. Mr. Weinstein. No, Mr. Matthews. Ms. D. Williams. All right, Mr. Botts on behalf of Mr. Nichols. All right, Mr. Short. Okay, anything further, Mr. Steele? In regards to that section?
Not the part that you just ordered to be staged or not played.
It's not going to be played.
I want to be clear that we're not just playing his name, but the fact he says, you know, my lawyer, and we'll stop where it says, before it says Brian. And then we'll play after that as well.
All right.
I don't know the relevance. And then it gets cut off. So I'm objecting to that.
To the relevance of, you know, my lawyer. Yeah. Or that part of the tape?
What difference does that make?
Okay. State?
We believe that as a part of the RICO conspiracy, the fact that the leader is offering up his lawyer to pay for another co-conspirator to get out of jail is relevant information. Who it is, that's fine. But the fact that he's offering up his lawyer for another co-conspirator is relevant.
Mr. Steele, anything else?
Yes, it was a conversation that got cut off. If you look at the records, or if the state bothers to look at the records, I did not have anything to do with Mr. Copeland ever. I don't know who represented Mr. Copeland, so I believe that it is irrelevant. It's just a conversation that was then cut off. So you don't get the entirety of the thought. So I do, if they're going to argue, they being the state's going to argue, oh, Mr. Williams is going to use his personal word. That's not a true statement, so it's misleading. It's an incomplete, it's unfortunate, but I don't think anyone did it. But I think the securist cuts off at
15 minutes, yeah. The other thing is, I think that, well, the court heard there's some conversation prior to that, because we played the last 2 minutes in regards to representation. So I think that's what it's made in reference to, even though they don't complete the conversation. But Ms. Hilton, anything else?
That will go to weight, not admissibility. He can surely ask, if he chooses to ask Mr. Copeland any questions, did you ever get a lawyer? So he can ask Mr. Copeland that question.
Mr. Steele, anything else before I rule?
I just don't think it's needed to say my lawyer. That's what I'm objecting to. I don't mind the conversation about, I need a lawyer. I think Mr. Williams says, get any lawyer you want, something to that effect. It's not a quote. But I don't see the need to say, I have my lawyer, I have his business card, I can call my lawyer. I don't see how that is relevant. And then it gets cut off. So I don't know if that means what the state is saying is, oh, and then he's going to get Mr. Williams' personal lawyer for Mr. Copeland. That's not what it says.
And that would be certainly speculation. That would be speculation, but I think they get at least to play, based upon what they proffered so far, I think they get to play it as subject, and also it's very limited as to what it can be said about it. Because unless Mr. Copeland, has some frame of reference, but.
I don't disagree with that, but I would like to leave it after I need money for a lawyer. These are not quotes. But, they're discussing, I need money for a lawyer. I don't know any lawyer. A statement is made, we'll get any lawyer you want, and then just end it there, rather than I have my own lawyer and I have him on Rolodex or whatever I don't think Rolodex would use, but whatever those terms are, at that point I would end it. That's my request to the court. I also object.
Let me see if the state has any
Your Honor,
further issues to that.
Your Honor, relevant evidence is any evidence that tends to prove an issue. We believe that the fact that the leader of the gang is offering up his lawyer to his co-conspirator is relevant for this jury to determine whether or not there is a RICO gang conspiracy. And so we believe that is relevant, because the argument is relevant. It also comes in because it's a party opponent admission. This is the defendant Williams telling Mr. Copeland that I will provide. He said, specifically what Mr. Copeland says is, I don't know any lawyers. And he said, you can call my lawyer, is what he actually says. So I think reading it in context, he's saying, okay, you don't know any, but I'll provide mine, or you can potentially use mine. Whether or not he used him or not, that is a question that can be asked of Mr. Copeland. But the fact that he was willing to offer up the lawyer is what is important, not the result of it.
All right. Sir.
I think this is a very bad point in our community if we are now going to say offering to get someone a lawyer is part of a RICO conspiracy. This is a probation revocation case on supposed non-compliance with community service. I know you haven't heard the whole.
I haven't, sir.
That's what the recording before we started at 13:30. That's what it's about. Mr. Copeland says, and it basically mirrors what he said on the witness stand. He said, the police had me locked up. These are my words, trumped up charges because my probation officer didn't take out a warrant on me, but the supervisor was asked by the police to take out a warrant on me because of community service hours. I will be getting out on Friday. This is a Wednesday. I'll be getting out on a Friday, and I believe it's a Wednesday. I'll be getting out on Friday when I go to court, but I don't have a lawyer, so it gets continued. for me to get a lawyer. So I'm held hostage basically by the way the courts are. So Mr. Williams is not part of any of that conversation. He then allegedly gets on the telephone and has a conversation, and that is explained to Mr. Williams as well. I go to court Friday, but I don't have a lawyer. To then say that it's part of a conspiracy to get a lawyer for someone going to court on a probation revocation case, I think is a bridge too far. To say you're going to get a lawyer, I don't have a problem with that. But to say I offered up my lawyer because that is symbolic of a crime, seems to me that if that type of evidence comes in courts, we are all in trouble, because that's what we want people to do. We want people to get lawyers. So I'm objecting to the state's playing that portion. I'm not objecting to the portion that Mr. Williams allegedly is on the phone and is offering to potentially help with a lawyer. I don't have a problem with that. If the state wants to then argue that's somehow part of a conspiracy, I'll argue against it. But to then go further and say, aha, and this is a crime organization and the lawyers are part of the criminal activity, I think that is under 403. It should never be said in any courtroom unless there's proof of it. That lawyers protect criminal parties.
Your Honor, the state never said, I don't even know where Mr. Steele got that last assertion from. The state said what is relevant is that he was willing to offer up his attorney to represent him. That is where it ends. And everything else Mr. Steele said is great for closing argument. But the relevance of it, it comes in, and then he can argue all of that, what he just said in closing.
It's relevant. It's more probative than prejudicial under 403, and I'm going to go ahead and I'll allow it. I'll give you a continuing objection, Mr. Steele, in that respect. Okay. All right. So what was the next thing you wanted to argue about, sir, or have me invite my attention to? As to the first call. Is it the first call or another call?
This is this call, but it's going to be for
Okay.
all of the calls.
Okay. All right.
There's portions of it that are just conversation about what other people said. I'm just using an example. Val, V-A-L, said that have 1 second.
In this call, Mr. Steele, or a different? Oh, I'm sorry. I don't. Your Honor, if you could answer, are we addressing the March 11th call?
I was gonna ask him for that clarification myself. Mr. Steele said it was this call and other calls, but he's making he's making, for example, and I think he mentions Val at that point in time, but I wanted to find out, is Val on the first call, second call?
I think this June 10th call, which may be the second call.
Yes, June 10th. That's the one at 2038, 4212, 10, 44. I'm sorry, 4 minutes, 12 seconds, 4 hours. Is it 4? Is it hours, minutes?
It's 4 minutes and 12 seconds to 11 minutes and 10 seconds.
Okay, thank you.
But
so can we just either close out or finish the March 11th? So we
all right.
But the state will ask the court.
I was attempting to say, but it's going to be overarching, but I could do it individually. So on each call, there are conversations about what did someone else say. So Mr. Copeland, allegedly, his voice is speaking with his girlfriend or significant other or the mother of his child. And he is saying, what did this person say? Well, this person said A, B, or C. I'm going to be objecting. I am objecting to anything that is hearsay. So for instance, in this call, Shannon said something. I'm not saying, Mr. Sharp and Mr. Botts can handle that for Mr. Stillwell, but I'm objecting to any third-party hearsay. They're not even on the call. I understand also that if Deshawn is not being called as a witness, which I believe she is not. I'm sorry, I shouldn't say Deshawn. The significant other, Mr. Copeland, I do not believe the state is going to call her. I don't know why her voice gets to be played on these recordings, unless she's somehow an exception to the hearsay rule. So I tell you that, Your Honor, because that is infected on each of these calls, because clearly there's another party on the call.
Another party that Mr. Copeland's talking to?
Who will not be testifying and who has not been classified so far as a supposed co-conspirator.
So, Your Honor, before we even get to these generalities, if we can just talk about each individual call, because I think it becomes confusing and timestamped, so we can know what you're objecting to and the basis of your objection, because some of what Mr. Steele is referencing, there's exceptions to why this should come in. And so I think that we need to take call by call, what is being objected to, so we can respond accordingly to that particular section.
You all have transcripts of these calls?
We do not have transcripts of the jail calls, but they're clear enough that you can hear what the issues are.
All right,
If
the
any.
challenge that we're gonna have is, without a transcript, you're gonna have to play these calls for me. Then each particular segment, unless you've identified that already, or this defense, Mr. Steele, I think you all are gonna have to identify that. Because what's gonna happen is, if it's played, we're gonna end up having this continual objection and potentially putting our jury out for periods of time to have me adjudicate that. So is it possible for you all to listen to the tapes, to the jail calls, and then flag those portions like you did for his interviews, to have me rule upon those? Because I understand what you're saying, Mr. Steele. It's a valid point. But what I don't want to do is, I want to minimize the disruption from the jury. So if we have agreement, then, or if you need to just object, I'll say as earlier noted. So, yes, I think that would be a much better way to potentially present this.
I could have that. I didn't write down the timestamp, but I could do that. So flag using the timestamp.
Yes. And then you could tell me, for example, to go to, 12 minutes and 15 seconds, it's hearsay, it's not within any exception, or it's speculation, or, whatever. And I'll let the state respond, and I can rule, kind of similar to what I did with the audio videotape interviews. If that's the case, I think that would probably be a better use of our time.
And again, Your Honor, the portions that we sent an email yesterday are the portions we intend to play. So there's only 2 calls that we intend to play the entirety of it, but the other calls, we've broken down specifically the areas that we think are relevant. So,
Okay, the first call is like 15 minutes.
so only the first and the 5th call are the full 15 minutes. The calls are 15 minutes. So only the first and the 5th, we intend to play the full calls. However, calls 2.
Is that the June 10th call at 2038?
Yes, Your Honor. So in the June 10th call, the only portions we intended to play is 4:12 through 11:10, and then picking back up again at 11:45 through 15:26.
All right.
And then for June 13th, the only portions we intend to play is 00 through 6:05.
That's still a fair amount of time, though.
It is. So they definitely, but I just want to make sure that they're not listening to the whole tape and saying, I want to just keep the guides of what we intend to play, so defense knows the parameters that we intend to play when they're reviewing it to determine to determine what they're objecting to.
Okay. Ms. Steele, give you just a thought. I need to consult with Ms. Chandler in just a second. How long do you think that would take? And I'll just ask you when we come back on the record, okay? All right. I'm just going to recess in place. Okay. All right. Okay, folks. I'll just direct Mr. Adams and Mr. Steele. You all go ahead and do that at this point in time, and then send what you feel you must to the state, and then we'll take it up either Monday the 1st of July or Tuesday the 2nd of July. As part, we left the Tuesday open anyways, the 2nd, to complete whatever was not done. So I think that we could probably handle that fairly comfortably on that morning of the 2nd, Tuesday the 2nd. Set. Okay. All right. So let's just plan on taking that up Tuesday morning, the 2nd of July, when we start. Our court. I'm gonna probably leave in probably about an hour. But tell me where you all are.
Would it be an impingement on on anybody if we got it in writing by tomorrow morning? That'd be okay? If it's not,
That's perfectly fine.
That's fine, Mr. Steele. Let's say by noon tomorrow. Would that be sufficient?
no problem, yes.
Okay, all right. Okay, so we'll take those up on Tuesday, July the 2nd, 10 a.m. Okay, anything else we need to take up at this point in time? Anything from the defendants?
No, sir.
Okay. Monday, the 1st of July, as I mentioned earlier, we'll bring your clients over. They'll be here. I'd ask counsel to meet 8F jury room for Monday at 9 o'clock. All right? For the in-camera review.
And on that, Your Honor, again, and I know I said it, so I'm assuming that it's preserved, but Mr. Williams would like to be present.
Yeah, you told me that already. Do you have any additional case law other than the United States 6th and Georgia 6th Amendments?
Georgia is Article 1, Section 1, Paragraph 12. I believe, Mr. Williams, I need him there to review. I assume we're getting a transcript. I don't know if that's.
I'll cover that on Monday. Mr. Williams will be brought over, but the part that you all are here just for in camera, that's attorneys because of the privilege potential that is that may be discussed, or no, I said not discussed, identified, and you all as lawyers are of course subject to the rules of professional responsibility. Third parties or your clients and other people are not.
Well, I oppose that objection.
And sir, if I have anything else, I will certainly reconsider that. But at this point in time, for that particular purpose, until we get through the in-camera review, I will when the transcript is reviewed, the court's intention is to review everything for for Brady and/or impeachment. And then I will flag all those, and then anything else that you all wished for me to consider, you can mark, and then we can have a discussion about that.
Okay, and I'd like it done in open court as well, in Mr. Williams' presence, of course, and in open court.
Okay, I don't think he can do, until I identify it, Mr. Steele, and make rulings on it, he doesn't have the right to be present. You're the person that's present for him at that point in time because it covers privilege. It's just like if you had defects records, okay? You and Mr. Williams could not come to my chambers and review those records. You could, but he can't. Now, once I've ruled upon those, of course, I will copy whatever periods of the transcript, portions of the transcript that I believe are appropriate, and I will make other rulings in regards to sealing that particular portions which are not for any other review, and then you can take that to Mr. Williams, and all of you can talk about that.
I understand. I just.
I know you've made an objection as to that, as to your client's presence, but for the privilege or for the in-camera review, he doesn't have the right to be there. I respectfully disagree, but.
I understand that we are in disagreement, but I'd also like to then wait. An open courtroom, I believe that it should be done in open court as well, and that's under Article 1 and.
Okay.
The first in the.
I understand that. I agree with you about the open court. I understand about the open courtroom. I agree with you about the respective constitutional provisions. I disagree with you about the in-camera. That doesn't apply to an open courtroom. The in-camera review of these records. So we'll just, like I said, if you got some case law, you got something for me to consider, I'll certainly look at it. But at this point, that's what my ruling will be in terms of your client's collectively presence. However, like I said, once the court makes those determinations as to which things are to be released to you, and I copy those transcripts for you, those portions or the transcript for you, then your clients will be here and you may take those portions and discuss those with your clients. Okay, and then we will have the rest of whatever we have in open court. Okay?
Understand the rule.
Okay, all right. Like I said, if you have some case law you want me to look at something, I'll certainly look at it. Because but that's.
I believe that under United States and Georgia Constitution and Presley, it's a voir dire issue, but I believe this should all be done in open court, not in a closed courtroom or closed chambers. jury room.
You are correct about anything else, but when you deal with when you're dealing with a matter of privilege and or depending upon the type of records you're reviewing, not everybody gets to see those. And that's where we disagree. That's not an open proceeding. That's a closed proceeding to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to your argument about that. That you don't get an open courtroom for, because I have to make a determination of whether or not first you get it and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's why, or else I give you the entire transcript. It would be fine for me, but I think that that's the issue.
If an attorney-client privilege conversation was captured by the court reporter on a transcript with the court present, it can't be attorney-client privilege.
Well, that's for another body to resolve, not me. And you'll have to first decide whether or not those conversations were had. So once you take a look at the transcript, then we can have the conversation again, because that will affect whether I seal it or not.
That's fine. I'm just want to continuing. I voiced it, so I think it's preserved. But
I think you've said it now 3 times. I think you've gotten your point across. But again, I'm going to tell you again, if you've got a case which says your clients can be present, I'll be more than happy to listen to you. I really will.
Well, my case is every case, but Penny, P-E-N-N-I-E versus State, Sammons, S-A-M-M-O-N-S versus State, Ward, Wade, W-A-D-E versus State, 1852. But the bottom line is, and they all say the same thing, at any critical stage of the proceedings, the criminally accused has a right to be present. I'm raising under federal as well as state constitution. I'm also raising an open courtroom, not a closed courtroom, under the right to public trial.
I understand that, sir, and I'll take a look at the cases you've cited, and that is part of what the court has to rule upon, whether or not it was in fact, or whether or not somebody else will rule upon, not me, I should say, whether or not it's a critical stage. But let me get through the review of the in-camera review first, and then we can have some other conversations. Okay?
No, I understand how it works. I just object. You're overruling it. I'm just
okay. All right.
Thank you.
State, you'll be able to as well join for those of you that were in there as well. I believe Ms. Hilton and Ms. Love for that same review. Okay. All right. Okay. All right, folks. I'll see you on Monday. All right. Enjoy the rest of your time.
Circuit Court is now in session. The Honorable Judge Baxter is now presiding. Court will now come to order.
Everybody have a seat.
All cell phones must be put away at this time. All cell phones must not be put away if you're not an attorney or the media.
So we're here for motions for new trial, is that correct?
That is what today was scheduled for, Your Honor. However, at this point in time, the parties have come to a resolution for the motions for new trial and the remaining direct review, and are submitting to the court a proposed resolution to resolve these 5 individuals' cases.
So how many do we have?
5 of the 6 whose direct review has not completed. The one who's remaining is somebody who you've already considered the motion for new trial for, so will require no further.
Okay, so
issue from the court.
that's, we will be finished today at the courthouse.
Yes.
Okay.
So as just a matter, we have Butler Webb, we have Copeland, we have Shawnee Robinson.
Michael Pitts and Sharon Davis Williams.
Thank you.
And Your Honor, may I put on the record what the agreement is essentially?
Yes.
The proposed resolution as to each of these individuals is that the trial conviction would remain absolutely intact. The length of the sentence and the number of community service hours would remain the same as originally imposed by the court. So basically everything will stay the same with few exceptions. The prison portion of the sentence would be converted to probation. The defendant would waive whatever direct review rights remain, whether it is both a motion for new trial and a notice of appeal, or just a motion for new trial, or notice of appeal for one defendant, excuse me. And as I talked to all of the opposing counsel today, any habeas rights, so basically the right to contest the validity of this conviction, is something that they would be waiving. The defendant would acknowledge on the record that the evidence presented to the jury was sufficient to sustain the jury's verdict of conviction or convictions against them. The defendant would apologize to the children of the city of Atlanta, and that would have to be the defendant's own apology. It could not be an apology for being prosecuted. Because what is contemplated would be OCGA